Most people think talking to police when you haven't done anything wrong is the safest move you can make. The Supreme Court ruled something that cuts directly against that instinct. "We just want to talk" sounds casual, friendly even, nothing like a threat. And that's exactly why it works, because the moment you start talking, voluntarily, before anyone has read you a single right, everything you say is fair game with zero legal protection attached to it. Before we go further, this is general legal education, not legal advice for your specific situation. Laws vary by state and by the facts of each case, so if this is actually happening to you right now, a licensed attorney in your jurisdiction is the call to make. Now, here's what's actually happening when those words come out of an officer's mouth. A voluntary conversation, one you entered freely before any detention, carries no Miranda protections whatsoever. None. Miranda only kicks in when you are in custody and being interrogated. Walk up to that conversation willingly, answer a few questions that seem harmless, and every word you just said is admissible, unprotected, and on record. You thought you were being cooperative. What you actually did was hand over a statement with no attorney, no warnings, and no takebacks. Here's the part that genuinely surprises people. Most folks assume that if they don't want to answer, they can just go quiet and let the silence protect them. The Supreme Court closed that door in Berghuis v. Thompkins, 2010. The ruling was direct. Simply staying silent is not enough to invoke your right to remain silent. You have to actually say it out loud. Passive silence without an explicit verbal invocation can still be used against you. That means the move most people instinctively make in this exact moment, just stop talking and hope it goes away, is the one move the court specifically said doesn't fully protect you. So here's what the law actually gives you in this moment. Terry v. Ohio, 1968. If you are not being detained, you are generally free to leave a voluntary encounter. And "we just want to talk" is, in most circumstances, exactly that, a voluntary encounter. You are not under arrest. You are not being detained, which means you have a door out of this conversation that most people never even look for. Here's the exact phrase. "Am I free to go? I'm not resisting, but I'm invoking my right to remain silent." Break it down because every word is working. Am I free to go? That question forces the officer to commit to a legal status on record right now, out loud. If the answer is yes, you walk. If the answer is no, you are now being detained, and detention requires its own reasonable suspicion that has nothing to do with whether you agree to talk. "I'm not resisting." That line stays in because it matters every single time. It tells him immediately and clearly that this is not a physical confrontation and you are not obstructing anything. "I'm invoking my right to remain silent." Those specific words said out loud are what Berghuis requires. Not silence, not a shrug. Those words spoken clearly, on record. Now, the one pushback you will almost certainly hear: if you have nothing to hide, why won't you just talk to us? You say nothing beyond what you already said. Your phrase is already on record. Answering that question, even to defend yourself, even to explain, even to say, "I just know my rights," reopens the conversation you just legally closed. The most dangerous thing you can say to "we just want to talk" is anything at all. One phrase, calm, legal, complete. Then you stop. If this is the kind of breakdown you needed, real rulings, real phrases, nothing stretched, there's a situation that follows this one almost every single time. What happens when that voluntary conversation flips into a detention without warning and suddenly leaving isn't an option anymore? That's a completely different set of rules, and that's coming next.